We will begin by reviewing the legislation that governs occupational health and safety in Ontario and discuss the concept of the internal responsibility system, which is the underlying philosophy of health and safety legislation in Canada. We will then review the roles and responsibilities required by workplace parties and employee rights identified in legislation. Finally, we will discuss workplace hazards, procedures to be followed in the event of an incident or accident, and workplace violence and harassment. We hope you find this training informative and that you use what you learn here as you work to keep you and those around you safe in the workplace. This is the university's health and safety policy, which states the university's commitment to the prevention of illness and injury at work and providing a healthy and safe workplace. The university endeavors to minimize hazards and risks by meeting or exceeding all relevant legislation and requires that health and safety be a primary objective in every area of operation. The policy also states the responsibilities of supervisors, employees, students, and tenants and contractors. It is reviewed and re-signed every year by the Board of Directors and is available on the York University website and U-Link. Please take some time to familiarize yourself with the policy governing health and safety at York University. This new requirement under the Occupational Health and Safety Act to provide health and safety orientation to new employees is based on statistics from the Ministry of Labour that show that younger workers and new workers, as in those that were most recently hired, are 3 times more likely to be injured in the first month of their employment when compared to more experienced workers. This training is designed to assist in the prevention of workplace incidents and injuries by making workers and supervisors aware of their roles, rights, and responsibilities in the workplace. In addition to these new training requirements, employers continue to have a responsibility under the Occupational Health and Safety Act to inform workers about specific hazards. This information is provided through specific health and safety programs, as well as training initiated through faculties, departments, and the Health, Safety, and Employee Wellbeing team. The Occupational Health and Safety Act is the legislation that provides the general requirements for workplace health and safety in Ontario. The Occupational Health and Safety Act also has several regulations providing more specific information and requirements pertaining to specific topics or areas. Some of the regulations that are applicable to York University include the industrial regulations, the construction regulations, regulations pertaining to confined spaces and critical injuries, regulations governing the control of exposure to biological or chemical agents, designated substances, and WHMIS. Some other examples of applicable legislation include the Workplace Safety and Insurance Act, the First Aid Regulations, and the Ontario Fire Code and Building Code. The Ontario Ministry of Labour, also known as the MOL, enforces the Occupational Health and Safety Act and regulations. The MOL often attends workplaces to conduct inspections or investigations, which can result in orders or recommendations. If violations of the Act or regulations are found, fines, charges, and orders may result against the employer, supervisor, or even workers. The Occupational Health and Safety Act is based on the concept of the internal responsibility system. The internal responsibility system establishes that everyone in the workplace, from the employer to the newest worker, has different but important duties to keep the workplace safe, and these responsibilities are connected. To achieve a safe work environment, everyone needs to do their part. Because employers have the most authority in the workplace, they have the greatest responsibility. The other parties identified in the Act, supervisors and employees, also have defined duties as they are in the best position to identify health and safety problems and develop effective solutions. It's important to note that there are internal and external resources to assist with health and safety in the workplace. Internally, every department and faculty has one or more assigned area health and safety officers who coordinate health and safety activities within their areas and serve as links to the central health, safety, and employee well-being team. Joint health and safety committees have an advisory role in the workplace health and safety that is defined in the Occupational Health and Safety Act. The York University has 5 joint health and safety committees. Additionally, the Health, Safety, and Employee Wellbeing team in Human Resources provides advice and guidance to the York University community on matters pertaining to health, safety, and employee well-being. If you are a member of a union and you feel that your employer has taken action against you for raising a health and safety concern, you can discuss it with your union, or you can file a complaint with the Ontario Labour Relations Board. Externally, partners in Ontario's workplace health and safety system include the Ministry of Labour, who develops, communicates, and enforces occupational health and safety requirements and employment standards, The Ministry of Labor also develops, coordinates, and implements strategies to prevent workplace injuries and illnesses and can set standards for health and safety training. The Workers' Health and Safety Center, which is an occupational health and safety training center for workers, representatives, and employers. Occupational Health Clinics for Ontario Workers, which has 6 medical clinics across Ontario that provide occupational health services and information. Health and Safety Ontario, which includes 4 health and safety associations, and the Workplace Safety and Insurance Board, who administers Ontario's no-fault workplace insurance for employers and their workers. Let's review some of the internal resources that provide health and safety support at York University. Every department and faculty have 1 or more assigned area health and safety officers who coordinate health and safety activities within their areas and serve as links to the Central Health, Safety, and Employee Wellbeing Team. York University also has 5 Joint Health and Safety Committees, also known as JHSCs. They are established by employee group and include USA, UFA, QP 3903, QP 1356, and IUOE. The Joint Health and Safety Committees have an advisory role in workplace health and safety that is defined in the Occupational Health and Safety Act. The Health, Safety, and Employee Wellbeing Team in Human Resources provides advice and guidance to the York University community on matters pertaining to health, safety, and employee well-being. Let's review the specific roles and responsibilities identified in the Occupational Health and Safety Act for employers, supervisors, workers, and the Joint Health and Safety Committee. The Occupational Health and Safety Act sets out specific responsibilities for employers in sections 25 and 26 of the Act. There is a clause in these duties referred to as the General Duty Clause, requiring employers to take every precaution reasonable for the health and safety of employees. Employers must ensure that workers know about hazards and dangers in the workplace and how to work safely. They must also ensure that workers are supervised by competent supervisors who know how to ensure the health and safety of their employees. We will review the definition of a competent supervisor under the Occupational Health and Safety Act in the next slide. Employers must ensure that specific health and safety policies and procedures are created and followed. The nature of the operation and the hazard will require the development of specific safety rules and procedures. Employers must post and share appropriate information, as specified in the Act, and provide and maintain a safe workplace, which includes equipment and protective devices, ensuring that they are appropriate, maintained in good condition, and used properly. Employers must also establish Joint Health and Safety Committees and cooperate and assist these Joint Health and Safety Committees if required. The Occupational Health and Safety Act defines a supervisor as any person who has charge of a workplace or authority over a worker. This means that an employee doesn't need to have the title of supervisor to be considered a supervisor under the Occupational Health and Safety Act, and therefore be required to carry out the roles and responsibilities of a supervisor as set out in the Act. A healthy and safe workplace matters to everyone, and the Occupational Health and Safety Act expects supervisors to be the frontline guardians of healthy and safe workers, whether the work is performed on a construction project, in a classroom, in an office environment, or in a lab. When appointing a supervisor, employers are required to appoint a competent person, which means a person who is qualified because of knowledge, training, and experience to organize the work and its performance, and is familiar with this Act and the regulations that apply to the work, and has knowledge of any potential or actual danger to health and safety in the workplace. Supervisors also have a general duty clause under the Act, requiring them to do everything reasonable in the circumstances to keep workers from getting hurt or sick on the job. Specifically, supervisors must ensure that workers comply with the law and any workplace health and safety policies and procedures, advise a worker of any potential or actual health and safety dangers known by the supervisor, ensure that any equipment, protective device, or clothing required by the employer is used or worn by the worker, and make sure that workers work safely and use protective equipment. This requires supervisors to show workers how to work safely and to follow up with workers and conduct inspections to ensure that workers are working safely. In addition to these duties, supervisors are considered to be workers and have the same workplace duties and rights as workers. As a supervisor, here are some questions that you should be asking yourself when implementing workplace health and safety in your workplace. Do you understand the Occupational Health and Safety Act and regulations that apply to the work you supervise, as well as any internal policies, procedures, and guidelines that apply? A supervisor who knows and understands the Occupational Health and Safety Act and regulations can make sure workers follow the law and can identify ways to make the workplace safer. The various regulations under the Occupational Health and Safety Act contain detailed requirements about how to make the workplace safe. Can you explain applicable legislation and internal procedures for working safely to workers? A supervisor needs to know and understand the legislative requirements in the Act and its regulations, and how this legislation applies to the area they supervise. This includes knowing and understanding applicable internal health and safety policy, program, and work procedures. Are you informing the workers about hazards? Every workplace has hazards. Hazards include anything in the workplace that can hurt workers or make them sick. A supervisor must know and be able to explain the actual and potential dangers involved in the work he or she is supervising and ensure that workers perform their work safely. Have you planned the work so that it can be done safely? The people you supervise are relying on your knowledge and experience of the work to make sure it's done safely. And finally, are you making sure workers wear protective gear, clothing, and devices required by the Occupational Health and Safety Act in York University? York has identified requirements for the type of protective equipment, devices, or clothing they require workers to use or wear, and both the supervisor and the employer are responsible for making sure workers are using or wearing it. That means as a supervisor, you need to know and understand the requirements in the Act and its regulations about equipment, devices, and clothing, including the employer's health and safety policy, program, and work procedures. Supervisors are important role models for following health and safety policies and procedures. Sometimes people want to take shortcuts because they think it will help them get the job done faster. Sometimes they're tired or they're having a bad day. As a supervisor, set expectations. If supervisors don't follow health and safety practices, others will think it's okay to not follow the workplace safety policies and procedures. People learn from their supervisors. How the work is supervised and how it is approached can affect the safety of the people being supervised. Help workers choose a safe path by being easy to talk to and answering their questions. Under the Act, workers have a general duty to protect their own health and safety and that of others around them. Specifically, workers must work in compliance with the Act and regulations, follow any specific workplace safety policies and procedures required by their supervisor and employer, use or wear any equipment, protective devices, or clothing required. This is to be used or worn safely and as shown by your supervisor. Workers must not remove or make ineffective any protective devices required by the employer or participate in horseplay. This means not using or operating any equipment or working in a way that may endanger any worker, and not engaging in any pranks, contests, feats of strength, or unnecessary rough or boisterous conduct. For example, racing powered hand trucks in a warehouse or seeing who can pick up the most boxes are examples of safe and unacceptable workplace conduct. Workers must also report any known hazards, dangerous situations, or missing or defective equipment or protective devices to their supervisor or employer. They must also report any known violations of the Act and any workplace incidents or injuries. As a worker, you cannot be reprimanded, called reprisal, for following the requirements of the Occupational Health and Safety Act and regulations. Under the Act, a workplace is required to have a Joint Health and Safety Committee, a JHSC, in all workplaces with 20 or more workers. As York employs more than 50 workers, the Joint Health and Safety Committee must have at least 4 people, with at least half of the members representing workers and the remainder representing management. The JHSC identifies workplace hazards and makes recommendations to the employer for improving health and safety. A JHSC worker member must inspect the workplace or parts of the workplace monthly. The results of these inspections are reported to management in the area being inspected and are reviewed at the JHSC meetings. The employer is required to provide information to the Joint Health and Safety Committees and respond promptly to recommendations made by the Joint Health and Safety Committee within 21 days. Joint Health and Safety Committees also participate in critical injury investigations and work refusals. York University has 5 joint health and safety committees. Employers are required to post and share information with employees. One way of doing this is through health and safety boards. York University has several health and safety boards across campus. The information that employers must post is shared on these boards and includes a copy of the Occupational Health and Safety Act, often known as the Green Book, York University's Health and Safety Policy and Workplace Violence and Harassment Policies, names and work locations of Joint Health and Safety Committee members, any written orders which may have been given by a Ministry of Labor inspector, valid first aid certificates of workers on duty, Workplace Safety and Insurance Board's In Case of Injury at Work poster, also known as Form 82, and the Ministry of Labor's Health and Safety at Work Prevention Starts Here poster. Let's review the specific rights that employees have under the Occupational Health and Safety Act: the right to know, the right to participate, and the right to refuse unsafe work. These 3 rights can easily be remembered as knowing your KPRs. Under the Occupational Health and Safety Act, employees have 3 rights: the right to know, the right to participate, and the right to refuse unsafe work. We will review these rights in more detail in the next few slides. The right to know is all about being provided with information so that you are able to work safely by identifying, assessing, and properly dealing with hazards in the workplace. More specifically, the employer must inform you of any known hazards in your workplace and provide training so you can work safely. You may be provided with safe work procedures or standard operating procedures, often known as SOPs, or simply instructions on how to do your job safely. The Workplace Hazardous Materials Information System, also known as WHMIS, is a system of providing information to all employees. This is an example of the right to know. Information on WHMIS is provided through worker education and training, labels for chemicals, and material safety data sheets which give specific chemical product information. As a worker, you also have the right to know that it's against the law for a supervisor or employer to threaten or punish or fire a worker for following the law. The right to participate. You have the right to participate in health and safety issues in your workplace. For all health and safety concerns, talk to your supervisor and your worker health and safety rep or members of your Joint Health and Safety Committee. Ask questions and keep asking them until you get answers so you can understand how to remain safe in the workplace. The right to refuse unsafe work. In most situations, unsafe conditions or health and safety concerns can be resolved by talking to your supervisor. It is up to you to tell your supervisor your concerns about unsafe work. Then it is the supervisor's responsibility to correct the problem. There are times when health and safety problems are not solved without some further intervention. You have the legal right to refuse unsafe work if there are reasonable grounds for you to believe the work is unsafe, either for you or for a coworker. There are 2 stages to a work refusal, and we'll go through these briefly in the next few slides. What it's important to note is that if the internal responsibility system is functioning in the workplace, work refusals are less likely to happen simply because issues are resolved between the supervisor and employee before requiring further intervention. The steps to follow if refusing unsafe work are set out in the Act, and if these steps have been followed, you cannot be disciplined for refusing to do unsafe work. Certain workers who have responsibilities to protect public safety cannot refuse unsafe work if the work is a normal part of the job or if their refusal would endanger the life, health, or safety of another person. For example, an experienced medical lab technologist could not, in the course of his or her regular work, refuse to handle a blood sample from a patient with an infectious disease. However, the technologist could refuse to test for a highly infectious virus if proper protective clothing and safety equipment was not available. There are 2 stages in the work refusal process. With the internal responsibility system, workers must report safety concerns to the supervisor. If the concern can be addressed, work resumes. If the issue remains unresolved, the supervisor and worker attempt to resolve the problem. Again, if the concern is addressed, work resumes. If the concern remains unresolved, stage 1 of a work refusal begins, and others are brought in to assist with resolving the concern. The worker representative from the Joint Health and Safety Committee is asked to attend and assist with the process, and other internal parties can also assist with resolution. If, through these efforts, the concern is addressed, work resumes. If the concern remains unresolved, then the issue moves to Stage 2 of the work refusal. In Stage 2 of a work refusal, the Ministry of Labor is called to assist with the resolution of the worker's concern. During Stage 2 of the work refusal, the worker must remain in a safe place. The worker may be assigned reasonable alternate work in the interim and is entitled to be paid regular hours until the work refusal is resolved. The work that has been refused can be assigned to another worker as long as the worker is advised of the work refusal. Workers who have acted in compliance with the Occupational Health and Safety Act are protected from reprisals. The Ministry of Labor will assign an inspector who will conduct an investigation of the concern with the worker, the supervisor, and the worker representative of the Joint Health and Safety Committee, and will issue a written decision regarding the work refusal. This must be posted at the workplace. Once the decision has been made and any recommendations are complied with, if applicable, work can resume. Now, let's review the roles and responsibilities for addressing workplace hazards, what a hazard is, categories of workplace hazards, and RACE, which is the process for recognizing, assessing, and controlling hazards and evaluating those controls. The Occupational Health and Safety Act sets out the following roles and responsibilities for employers, supervisors, and workers to address workplace hazards. Employers have a duty to make sure that supervisors know enough and have enough experience and training to keep workers safe and healthy while they work. Employers and supervisors have a duty to inform workers of health and safety hazards. This includes general workplace safety information, such as an overview of workplace health and safety and roles and responsibilities, the organization's health and safety policy and rules, and first aid locations and procedures, as well as workplace-specific safety training, which includes applicable safety procedures for the work being performed, emergency procedures, how to use protective guards, safety features in the workplace, and information about personal protective equipment. Health and safety training may be done by the employer at your workplace or may require you to attend training outside of the workplace. Workers have a duty to report hazards they know of to the supervisor or employer as soon as possible so that they can be fixed. Some hazards may be straightforward and easy to identify and deal with, while others may not. For example, things like chemicals, fumes, toxic dust, or germs and viruses in workplaces may not be obvious at first, especially if these are not part of your normal work duties or are a byproduct of work happening nearby. A hazard is an unsafe act or condition that, if not controlled, could cause an injury or illness to an employee. So essentially, a hazard is anything in the workplace that could hurt you or the people you work with. There is a hazard at the root of every work-related death, injury, or illness in the workplace. A hazard only represents a potential to cause harm. Whether it actually does cause harm will depend on the circumstances, such as the toxicity of the hazard, the amount of exposure, or the duration of exposure. As a worker, you need to know about the hazards in the workplace before you start working, and supervisors must ensure that workers are aware of hazards and how to protect themselves before they begin work. Here are some examples of common workplace hazards. Physical hazards include temperature, noise, vibration, radiation, slips, trips, and falls, machinery, and workplace violence and harassment. Slips, trips, and falls can result from something as simple as spilled coffee on the floor, a cluttered work area, a slippery surface, or a raised platform with no guardrails. Improper housekeeping is another example of a physical hazard and includes blocked electrical panels, first aid kits, fire extinguishers and fire exits, and unsafe storage areas. Examples of biological hazards include mold, infectious materials, sharps, bodily fluids, and germs and viruses in labs and healthcare workplaces. Examples of chemical hazards include chemicals, fumes, toxic dust, or byproducts of other chemicals or work in the workplace. Ergonomic hazards can result from repeating the same movements or actions over and over, especially if you are in an awkward position or you use a lot of force, and improper manual handling, such as lifting or transferring materials unsafely. WHMIS stands for Workplace Hazardous Materials Information System, which is a regulation defining the requirements for working with controlled products, requiring worker education, proper labeling of controlled products in the workplace, and material safety data sheets to provide information about these controlled products. Under WHMIS, every worker must have information and training about chemicals or hazardous materials in the workplace prior to working with any controlled products. Workers must be trained on how to use, store, and dispose of hazardous materials safely, and where to find information on warning labels and information sheets. At York University, there are different levels of WHMIS training, depending on the nature of your work. You are required to take WHMIS training. Please ensure you receive the appropriate training prior to working with controlled products. Now that we've discussed what a workplace hazard is, let's discuss how a supervisor can determine the severity of the hazard and control the risk. There are 4 steps for dealing with workplace hazards that can easily be remembered by the acronym RACE. First, hazards must be recognized, then they must be assessed, and finally they must be controlled. These steps, when done in order, help the workplace identify and control hazards. Supervisors are encouraged to communicate with workers, the employer, and the Joint Health and Safety Committee or Health and Safety representative throughout this type of process. The first step in controlling hazards is recognizing where there are potential hazards in the workplace. Supervisors can do this by watching the work as it's being done, talking to workers about the work and the areas where work happens, participating in workplace inspections, looking at reports and records that your workplace has about the work, and listening to the concerns workers have about the work they're doing. Now that you are able to recognize a workplace hazard, how do you determine the severity of the hazard and control the risk? The next step in the process is to assess the hazard to understand how likely it is that a worker will get hurt or made sick by the hazard. To assess the hazard, think about how the hazard compares to legislation, standards, and guidelines. How will the workers get hurt or sick? How likely is the hazard to affect worker health and safety? And how badly could the worker get hurt? Control the hazards by looking for ways to get rid of the hazard or make the job safer. The safest thing to do is remove the hazard either through elimination or substitution. If removing the hazard is not possible, look for ways to prevent workers from coming into contact with the hazard, such as separating the hazard from the worker. If neither of the above solutions protect the worker, workers can use protective equipment, devices, or other materials to help keep them safe. As a supervisor, it's your obligation to make sure that workers use the equipment where required by the regulations or by the employer. The last step in the process is evaluating how well the hazard controls are working. Talk about the work to the workers who report to you. Watch them do their work. Listen to what they say and look for ways to improve their health and safety in the workplace. Let's quickly discuss how to assess hazards to determine how likely it is that a worker will get hurt or sick from the hazard. Hazards are assessed by determining the danger and the type of injury they can cause. You can choose to classify the hazard into one of 3 categories to help determine the severity of the hazard. High hazards have the potential for critical or disabling injury, loss of life, major structural or equipment damage. Medium hazards have the potential for injury or illness or property damage. And low hazards have the potential for non-disabling injury or non-disruptive property damage. Now that you are able to recognize and assess workplace hazards, let's review what can be done to control them. There are many ways to control workplace hazards. The most effective way to control a hazard is to remove the hazard, either through eliminating it or substituting it with something less hazardous. For example, replacing a toxic cleaning chemical with one that is non-toxic, or designing equipment to eliminate hazards. Often, it is not possible or practical to remove the hazard. If this is the case, then we need to look for ways to prevent workers from coming into contact with the hazard or limit the amount of time a worker is exposed to the hazard through engineering or administrative controls. The consequences of exposure to some hazards may be so harmful that, even if there is little chance of a worker being exposed, the risk is so great that extreme precautions must be taken to prevent even that small possibility. Some examples of engineering controls are installing fume hoods and ensuring adequate ventilation to reduce exposure to gases or fumes, or putting a barrier around a dangerous piece of equipment. An example of administrative controls is rotating tasks to reduce exposures to repetitive movements. If the above solutions don't provide adequate protection, workers can use protective equipment, devices, or other materials to help keep them safe. It's the supervisor's duty to ensure that workers use this equipment where required by the Act and regulations or by employer procedures. Here are 4 important questions about your job that you should be able to answer before you start working. What are the hazards of this job? Is there any special training needed for this job? Do I have the right personal protective equipment for this job? If I have any questions about safety, who do I ask? If you don't know the answer to any of these questions, ask your supervisor before you start work. Let's review the procedures to follow to report workplace incidents and accidents, critical injuries, near misses, and the procedures for first aid and fire evacuations. As a worker, you have a duty to immediately report any hazards in the workplace to your supervisor or employer and any incidents or accidents, including critical injuries. We will review what a critical injury is and reporting procedures for critical injuries in the next few slides. Accidents requiring first aid, medical attention, or time lost from work, and occupational illnesses. These involve the completion of a supervisor's accident investigation report, known internally as a SARE, and some require reporting to the Workplace Safety and Insurance Board, also known as the WSIB. Workers must also report near misses. We'll review what these are and how you report them in an upcoming slide. Incidents of workplace violence or harassment, chemical spills and releases, motor vehicle accidents involving York vehicles, and incidents involving damage to York property or equipment. A critical injury is defined in the Occupational Health and Safety Act as an injury of a serious nature to any person in the workplace that results in one of the following: places life in jeopardy, unconsciousness, substantial loss of blood, fracture of a leg or arm but not a finger or toe, amputation of a leg, arm, hand, or foot but not a finger or toe, burns to a major portion of the body, or loss of sight in an eye. For serious injuries not mentioned above, or if you're not sure if it's a critical injury, treat it as such and follow the reporting procedures that we will review in the next slide. The following procedures should be followed for any critical injury or suspected critical injury to any person, not just employees, in the workplace. Immediately arrange for medical and emergency assistance by calling 911 and campus security, who will meet and expedite emergency vehicles directly to the scene. Campus security can be reached at extension 33333 or at 416-736-5333. Once it is reasonable to do so, notification should be made to the Health, Safety, and Employee Wellbeing Team at extension 55491 or 416-736-5491. After arranging for medical and emergency assistance, ensure further injury is prevented by securing the accident scene. According to the Occupational Health and Safety Act, the accident scene must not be disturbed until released by the Ministry of Labor, except to save a life, relieve suffering, maintain utilities, or prevent unnecessary damage to equipment or property. If required, enlist the help of security to secure the scene. Report the incident to the Ministry of Labor. The Health, Safety, and Employee Wellbeing Team and/or the supervisor or person in charge will report the incident to the Ministry of Labor as well as to the relevant Joint Health and Safety Committee worker, co-chair, or member. Report the incident to other internal parties as necessary. The Health, Safety, and Employee Wellbeing Team and/or the supervisor or person in charge will contact any necessary internal parties, including communications, risk management, university legal counsel, as well as the appropriate department head. If the critical injury is as a result of electrical contact, the Electrical Safety Authority must be notified. The supervisor or person in charge and the Joint Health and Safety Committee certified worker representative will conduct an investigation and complete a supervisor's accident investigation report with assistance from the Health, Safety, and Employee Wellbeing Team as necessary. If you are involved or witness a workplace accident, you must participate in the accident investigation. The Health, Safety, and Employee Wellbeing Team and the supervisor or person in charge will ensure that a written notice of death or injury report, as required by the Occupational Health and Safety Act, is completed and forwarded to the Ministry of Labor within 48 hours of the time of the accident. This written notice of death or injury report is in addition to the supervisor's accident investigation report, the SARE. These bulletins are posted throughout campus to remind you of the process for reporting any injuries suspected of being a critical injury to any person in the workplace. The following procedures should be followed if an incident or accident occurs in the workplace. If required, arrange for medical assistance or first aid. This may include making arrangements to transport the employee to medical care and/or to their home if necessary. Ensure that you report the incident or accident to your supervisor. The supervisor will conduct an accident investigation and complete a SARE, a Supervisor's Accident Investigation Report. The Joint Health and Safety Committee assists in the incident and accident investigation process if needed, reviews all incident accident reports, and makes recommendations to prevent a recurrence. Cooperate with the incident accident investigation. Fill out the witness statement if applicable. All incidents and accidents reported by employees are investigated as soon as possible, and when appropriate, proper corrective actions are taken to prevent further injury. A near miss is any incident in the workplace that does not result in injury to a worker but had the potential to cause injury. For example, a bookshelf falls off the wall in a room near a worker but does not make contact with the worker. In this case, no one was injured, but the potential for injury is there. Why is it important to report these? Reporting near misses enables the supervisor to investigate the cause of the accident to prevent future accidents and injuries. In the example above, reporting this ensures that prevention measures are implemented to prevent such incidents from occurring again. To ensure your safety in the event of an emergency, you should be familiar with the location of your nearest first aid kit and certified first aid attendant. If you do require first aid, ensure that this is reported to your supervisor and documented. And the location of your nearest fire exit and your building fire evacuation procedures, including your designated assembly area. Now we'll spend some time discussing workplace violence and harassment. We all like to think of ourselves as being safe and secure while at work. However, wherever people interact, there is potential for violence. Workplace violence affects all business sectors and occupations and affects the safety and security of every employee and employer. York University's workplace violence and workplace harassment policies apply to all persons working for York University, including students, faculty, staff, and volunteers. All acts of workplace violence and harassment which occur at the university must be reported and will be investigated, following which appropriate action will be taken. The Occupational Health and Safety Act includes specific legislation pertaining to workplace violence and harassment, requiring all employers with more than 5 workers to conduct workplace violence risk assessments and to reassess this risk as required, develop and post workplace violence and harassment policies and review them at least once a year, develop a program to implement the policies, provide information and instruction to workers on these policies and programs. Under the Occupational Health and Safety Act, workplace violence is defined as the exercise of or an attempt to exercise physical force against a worker in a workplace that causes or could cause physical injury to a worker. This includes a statement or behavior that is reasonable for a worker to interpret as a threat to exercise physical force that could cause physical injury. The definition of workplace harassment under the Occupational Health and Safety Act addresses all forms of harassment, including those that go beyond the prescribed grounds for the Human Rights Code. The legal definition is engaging in a course of vexatious comment or conduct that is known or ought reasonably to be known to be unwelcome. This includes bullying and can involve unwelcome words or actions that are known or should be known to be offensive, embarrassing, humiliating, or demeaning to a worker or group of workers. Any behavior that intimidates, isolates, or discriminates against a targeted individual or individuals can be interpreted as harassment. The definition applies to any person making comments or behaving in a way that they know or should know is unwelcome. What types of behaviors do you consider to be workplace violence? Workplace violence includes the obvious things you may think of: vandalism, theft, physical assault, rape, arson, murder, inappropriate verbal comments or physical contact, unwelcome remarks, and bullying. There are several other examples of behavior that can be considered violent or harassing. All of these behaviors are examples of workplace violence if they occur in situations related to your work. Most people only think of violence as a physical act. However, workplace violence is a much broader issue. Violence includes, but is not limited to, threatening behavior, for example, physical intimidation, throwing objects, property destruction, or other anger-related acts, verbal or written threats, any expression of intent to inflict physical force that could cause physical injury, and physical attacks, such as hitting, pushing, kicking, punching, or otherwise physically assaulting someone. Behaviors that are seen as personal or psychological harassment include, but are not limited to, any attempt to embarrass or humiliate by using inappropriate comments or jokes, unwelcome words, or actions that are known to be offensive, embarrassing, humiliating, or demeaning to a worker or group of workers. Behavior that intimidates, isolates, or discriminates against a worker or group of workers, such as deliberately cutting a coworker out of communications, not returning emails or phone calls, not sending relevant emails or passing on important information, or otherwise sabotaging a person, ignoring a coworker by giving them the silent treatment, bringing refreshments for everyone except the targeted coworker, or similar exclusions, or making up new rules for a targeted person while exempting others. Repeated words or actions or a pattern of behaviors against a worker or group of workers in the workplace that are unwelcome. It is important to understand that a supervisor or manager who provides direction, counsel, discipline, or performance reviews as part of his or her job is not considered to be harassing their workers. Workplace harassment does not include rudeness, unless extreme, demotion, legitimate performance management, operational directives, job assignments, inadvertent management errors, or a single incident unless grave or harmful. Consider if these following scenarios are considered workplace harassment. Click on each scenario to hear the answer. Try a few of the following scenarios to assist you in understanding the definition of workplace harassment and the resolution process.